A federal judge is blocking part of a California law that requires certain safety features on handguns. Those features required on new handguns include an indicator that shows when the gun is loaded, a mechanism that prevents firing if the magazine isn't fully inserted, and the ability to stamp shell casings, making it easy to identify which gun they came from.
A federal judge has blocked parts of California's handgun law. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms, your NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And if you like my channel, like my content, and wish to support me through, financially, you can use the links in the description box below. Everything is appreciated. But let's talk about this. Now, if I've spoken on this issue before, where California in 2007 implemented a micro-stamping rule that every firearm coming into the state must meet the specific safety guidelines, which micro-stamping is one. And basically, if you remember, I talked about where the inventor and the patent holder of that technology testified in Connecticut at the last public hearing that they had, and he openly admitted that the technology is not there and is flawed. But California, since 2007, has been using that micro-stamping rule to ban swaths of firearms from being imported to the state because the manufacturers could not meet the requirements, safety requirements that California had put in place. As if you remember, Governor Lamont here in Connecticut is trying to implement the same rule to do the same exact thing. But a federal judge has stepped in California, and he is blocking parts of that law. I got a little clip here so you can get context. Let's go ahead and watch that.
This all falls under California's Unsafe Handgun Act, which barred people from purchasing handguns that don't comply after 2013. The thing is, guns with those features weren't being manufactured after 2013. So last year, the California Rifle and Pistol Association and several individuals brought a lawsuit saying the law denied residents their Second Amendment rights. This comes after a Supreme Court ruling last year that blocked gun restrictions in New York State. A U.S. District Court judge, Cormac Carney, agreed, writing, quote, "No handgun available in the world has all three of these features." The state will stop enforcing the law when the judge's preliminary injunction begins in 2 weeks, unless there's an appeal. The state attorney general, Rob Bonta, said in a statement, quote, "We will continue to lead efforts to advance and defend California's gun safety laws. As we move forward to determine next steps in this case, Californians should know that this injunction has not gone into effect and that California's important gun safety requirements related to the Unsafe Handgun Act remain in effect."
Heard that and you saw that. So, the judge is absolutely correct. There is no firearm that can meet California's requirements for safety. None. And he is basically catching on to the same thing I've been saying, that they're using this to basically hamper good people from exercising their rights under the Constitution, the Second Amendment specifically. So I'm going to jump into here. This is Fox 11, this is our Los Angeles local affiliate, titled "Federal Judge Blocked Key Parts of California Handgun Law." And we're just going to briefly look at this to get ourselves some knowledge on it. And this was dated March 21st of this year. Los Angeles. A federal judge on Monday blocked key provisions of a California law that drastically restricts the sale of new handguns in the state, saying parts of the legislation violate the Second Amendment. Of course it does. But a lawsuit challenging the law was filed last year by the California Rifle and Pistol Association and other gun rights supporters following a landmark 2022 decision from the U.S. Supreme Court that set new standards for evaluating firearm restrictions. Bruen strikes again. The ruling left many laws aimed at regulating, eliminating the sale and use of guns in California and nationwide at risk of being struck down. Good. U.S. District Judge Cormac Carney, sitting in Santa Ana, wrote Monday that California's requirements for new handguns are unconstitutional and cannot be enforced. Because of these restrictions, Carney wrote, no new models of semi-automatic handguns have been approved for sale since 2013. and Californians are forced to buy older and potentially less safe models. He issued a preliminary injunction to take effect in 2 weeks, meaning the state would have to stop enforcing the law. The delay gives the State Department of Justice time to appeal, which you know they will. Quote, the matter of fact is, California's gun safety laws save lives, and California's Unsafe Handgun Act is no exception, Attorney General Rob Bonta said in a statement. Gaslighting. We will continue to lead efforts to advance and defend California's gun safety laws as we move forward to determine next steps in this case, which means they're going to waste taxpayers' money to push a useless point. But California should know that this injunction has not gone into effect and that California's important gun safety requirements related to the Unsafe Handgun Act remain in effect. In California, state law requires new handguns to have 3 components: a chamber load indicator, which shows whether the gun is loaded, a magazine disconnect mechanism that will stop the gun from firing if the magazine is not properly inserted, and micro-stamping capability so law enforcement can easily link spent shell casings to the guns they were fired from, which, if you remember, New York many years ago had a shell casing. Basically, any gun that went into New York had to have a spent shell casing too, that they could then put into a database to then track. Like if a gun is used in a crime, they could use the casings from the crime and go against the database to find out which gun fired it. They actually abandoned that entire scheme because it was costing too much money and wasn't producing any results. So there you go. Quote, no handgun available in the world has all 3 of these features, the judge wrote. These regulations are having a devastating impact on California's ability to acquire and use new state-of-the-art handguns. Older handguns have been grandfathered into what's known as the roster or list of guns that passed a safety test under state law known as the Unsafe Handgun Act. I wonder who comes up with these titles. Quote, Californians have the constitutional right to acquire and use state-of-the-art guns to protect themselves, he wrote. They should not be forced to settle for decades-old models of handguns to ensure that they remain safe inside or outside the home. Previous attempts to challenge the state law filed before last year's Supreme Court ruling failed. Chuck Mitchell, head of the California Rifle and Pistol Association, said the three requirements were impossible to satisfy, but that's the point. That's exactly the point of it. No new handguns made will be able to meet these 3 requirements. So you can't import the gun into the state. So new handguns cannot be sold, new models. If like the Glock, Gen 4s and Gen 5s can't be bought or sold in California. Quote, for decades, this roster law has deprived law-abiding citizens of the right to choose a handgun appropriate for their individual needs, he wrote in a statement Monday. If we can hold on to this great Second Amendment win, people will be able to choose from among thousands of the latest, greatest, and safest handguns made today. And only New York has a similar micro-stamping requirement, according to gun control group Every Town for Gun Safety. The National Shooting Sports Foundation, the trade association for the firearms industry, hailed the preliminary injunction in a statement Monday. Quote, for too long, the Second Amendment has been significantly infringed upon by elected officials who have taken every opportunity to put roadblocks in front of law-abiding citizens seeking to exercise their Second Amendment rights, said Lawrence Keene, the organization's senior vice president. The order is the first step in what would be protracted legal battle, but is a significant win. So there it is. So there's the next positive step, which, as I said, Lamont here in Connecticut wants to try to implement the same thing. Now, I would say hopefully this will give him pause, but he just tends to do whatever the hell he wants, regardless of whether it's unconstitutional or not, and then cries about safety as the platform to why he's doing it. And nothing that he proposes ever accomplishes the task that he claims it will. Because in the end, it's not about nobody's safety. It is literally about hampering the rights under the Second Amendment. That's what he's about. I've said a few times over and over again, for those of you who watch me on a regular basis, that Lamont's not interested in your safety. He just does not want the public to have firearms. And if he could just arbitrarily ban them across the board, he would have done it already. But he can't, and he knows he can't. That's what's holding him back. But he's still trying to sneak out there and do little things here and there to basically hamper the law-abiding while the criminals run the streets. And I will talk about that in another video. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I will see you on the next one. Peace.